King's Counsel, and Mr. Pressman represent the interests of the respondent claimant, Martin Warren. I trust that the core bundle, the supplementary bundle, and the authorities bundle have reached the court, and my lady and my lords have had the chance to consider at least the core bundle, which contains the grounds of appeal, the judgments below, and the skeleton arguments.
Yes, thank you, and I think you can assume that we've read quite widely.
Thank you very much, my lady. The context of this appeal is the claimant made an application in February of 2022 for permission to rely on expert evidence in a new discipline, namely a pain management consultant, and to serve a report from that expert at a date in the future to be determined by the court. The application was made about 18 months after Mr. Quayle, the claimant's orthopaedic expert, had recommended a pain management assessment, 17 months after the Costs and Case Management Conference in October 2020, at which the court had given directions and had granted permission for orthopaedic evidence, about 1 year after the date the court had set for the service of orthopaedic evidence, which was in March of 2021, over 4 months after the court had ordered the parties to file any application to call oral expert evidence at trial, which was in October 2021, or was due by October 2021, and over 3 months after a pre-trial settlement hearing in November 2021, at which the court had overseen a mediation appointment and given directions for trial. At the time the application was made, the case was simply awaiting a trial. It was granted in August of 2022 by District Judge Stewart, as you've seen. The judge had already vacated 2 successive trial fixtures in April and September of 2022 due to the claimant's unavailability. The defendant appealed, and that decision was upheld by His Honour Judge Glen. The district judge at first instance did not apply the Denton test, and he gave permission to appeal on the basis that he may have been wrong not to do so, which is apparent from the form that he filled in on page 13 of the supplementary bundle. Nonetheless, His Honour Judge Glen held the Denton test did not apply to the claimant's application, following the decision of Mr. Justice Stewart in T. a Child and Imperial College Healthcare NHS Trust, reported in 2020 England and Wales High Court at page 1147. Now, permission to appeal was granted by Lord Justice Lewison on the 14th of February of this year. The order granting permission to appeal is at page 66 of the core bundle. That order in my submission did not limit permission to ground 1 as the respondent's skeleton argument asserts. And permission to appeal was sought on grounds 1 and 2 as set out on page 16 of the core bundle. And the grounds or the decision was, looking at page 66, decision was granted. The grant was not qualified in any way. And I submit it's not legitimate to infer from the summary of reasons in that document that permission was not granted for ground 2 or that ground 2 was somehow excluded. There's nothing to indicate that was the judge's decision at all in the document that he completed. And in my submission, if that had been his intention, that would have been made clear. Clearly, at this stage, the judge had to consider whether the appeal raised a point of importance, public importance, which went beyond perhaps the instant facts of the case itself. And no doubt that was why, when he outlined his reasons for granting permission, he focused on that. But when a judge grants permission to appeal, broadly, as it was the case here, he doesn't have to set out his reasons for granting permission to appeal on each and every ground in my submission. He simply needs to say whether permission is granted or not, and if permission is granted for some grounds and not others, then the decision will be granted on grounds 1, 2, whatever it is, refused on 3, 4, etc. It's not right, I submit, to infer from the document that was filled in that permission for ground 2 was somehow excluded, because there's no caveat to it.
Speaking for myself, it seems to me, looking at the permission to appeal, that it is a blanket permission to appeal in relation to the grounds which were before Lord Justice Lewison. But in any event, if you proceed to deal with both, and then that issue will be addressed at the end rather than the beginning.
Thank you, my lord. Ground 1 of the appeal, which is, as I say, set out at page 16 of the core bundle, is the judges below failed to apply the Denton test, and there's no dispute that they didn't do so. The issue is whether in law they should have done. In my submission, the Denton test applies, or should apply, when 3 conditions are satisfied. First, where there was a breach of a rule, practice, direction, or court order. Second, where there was a sanction as a result, however imposed. Third, where a retrospective application was necessary in order to avoid the consequences of the sanction. Now, I appreciate that formulation of the test is wider than that envisaged by CPR 3.8 and 3.9, as one can see from, which one can find, at page 125 of the authorities bundle. 3.8 states,
125.
125 of the, sorry, I'm so sorry, it's page 281 of the authorities bundle.
281.
281, 125 is the page number at the bottom, and it's the page numbers at the top that I should have referred to. It's 281 of 311. 3.81 states, where a party has failed to comply with a rule, practice, direction, or court order, any sanction for failure to comply imposed by the rule, practice, direction, or court order has effect unless the party in default applies for and obtains relief from sanction. In other words, 3.8 envisages that the sanction is contained in the rule, practice, direction, or court order that was breached. However, in my submission, if the sanction arises from a different rule, practice, direction, or court order, it is difficult to see why a different test should be applied, and I submit it should not. And can I now ask my lady and my lords to look at the case of FXF versus Ishinru Karate Association, the reference for which is 2023 England and Wales Court of Appeal Civil at 891, and that can be found.
Just before you you do that, if you wouldn't mind,
yes, of course.
Can you identify for us what in your submission is the rule, practice, direction, or court order of which there was a breach in this case, your first point, and what you say is the sanction which we find in the rules, just so we see where you're going.
Absolutely. I will develop that in due course. Just for now, the rules, first of all, there was a breach of the order of the 3rd of August of 2020. There was a breach 3rd of August of 2020.
Yeah.
Page 14A of the supplementary bundle. Second, I'll come to the details in a moment. Mm-hmm. Second, there was a breach of CPR part 29.4. Third, there was a breach of practice direction 29, paragraph 3.5. Fourth, there was a breach of Practice Direction 29, paragraph 5.6. Fifth, there was a breach of Practice Direction 29, paragraph 6.21. And sixth, there was a breach of the order of the 19th of October 2020, in particular paragraph 11. And I will outline, I fully expected this question to be asked, and in fact I'm going to deal with it when I develop the submission as to why the Denton test applies. But I'm going to do it step by step, if I may, and I'm going to do it by reference to by reference to the three questions I outlined at the start. First, was there a breach? I'll outline the breaches and explain why. Second, was there a sanction as a result of those breaches? And I'll outline the sanction and explain why. And then third, I don't think there'll be much dispute that there was the retrospective application given when it was made. If I'm right on the first 2 points, then the third will follow. And I will deal with that, but I want to develop that submission by reference to the facts of the case and not do so in abstract. And I'll come to that in a moment, but I just first briefly want to review the law, if I may, because that sets the context against which my submissions on the facts of this case are made.
I'm glad I asked, because I don't think I have page 14A of the supplemental bundle.
It was sent to the court last week. I'm so sorry.
Well, what I did get was a completely new bundle, which didn't, to my mind, explain what was new. And as I'd already read material,
yeah, I'm so sorry about that.
Is there a reference for the 19th October order?
There is indeed. It is in the supplementary bundle, my lord. One moment. It is at page 15, and the order that was breached, paragraph 11 on page 16 of the supplementary bundle. Well, I have a copy of the...
Well, that's very kind.
I know what we're talking about here, Mr. McLaughlin. The reference you've given me, page 16 of the bundle, that's the order sealed on the 15th of August.
Precisely, yes. No, that's the order which is date of the supplementary bundle is dated the 19th of October. That's the order that was made at the CCMC. It appears that the order of the 3rd of August it was omitted from the bundle that was submitted inadvertently, and it was then sent last week, and a request was made for it to be inserted.
I had, like my Lord Justice, mails a new supplementary bundle. I have in it pages 14A and B, which are on the order of the 15th of August, 2020.
Forgive me, but if you look carefully at that order and you look at the first line of it, you'll see it was an order made on the 3rd of August. It was drawn on the 15th.
Okay, so same difference, same one.
Sorry.
Okay, and then you were taking us to page 16.
Page 16 of the supplementary bundle.
And I'm not sure it's my page 16.
It should be the second page of the order made at the CCMC.
Parties shall file pre-trial checklists, that one.
That's the one.
Yeah. Yes, okay. Thank you, I'm sorry, I have the right...
It seems that...
that will be very helpful.
I'm so sorry, you haven't got a copy. Could I possibly arrange that to be handed up now, so that...
Excuse me.
Could you possibly just hand that to first? Thank you. Thanks very much. Thank you.
Thank you.
Thank you very much indeed.
So, FXF then, if I may please, which starts on page 4 of the authorities bundle, and this is a decision which was, I think, handed down by this court on the 26th of July of this year, so it post-dates the skeleton arguments in this case, and the relevant parts of it, which I would direct my lady and my lord's attention, are paragraphs 59 and 65 of the judgment of Sir Geoffrey Birss, which can be found on pages 19 and 20 of the bundle itself. And perhaps if I could just take a moment to allow my lady and my lords just to read paragraph 59 and then to read paragraph 65. In paragraph 59, the court recognised three categories of case. First, cases where the rule or order expressly provides for the sanction that will apply on non-compliance. In the context of expert evidence, one example of that is Rule 35.13, which the court will find on page 295 of this bundle. Rule 35.13 provides, a party who fails to disclose an expert's report may not use the report at the trial or call the expert to give evidence orally unless the court gives permission. In my submission, that means if a party is granted permission to rely on an expert's report and is ordered to disclose it by a certain date, and that party fails to do so by that date and doesn't make a prospective application, then the party requires relief from sanction. The sanction set out in 35.13. An example of this approach, albeit a case not actually referring to this rule, is the Court of Appeal decision in Boyle and the Commissioner of Police for the Metropolis, England and Wales Court of Appeal, Civil 1477, which is available at page 50 of this bundle. To set the context of this case, the claimant had been granted permission at a CMC to rely on, amongst other things, expert evidence from a spinal surgeon. That's apparent from paragraph 10 of the judgment. He was ordered to serve it by a certain date but didn't do so. An application was made to rely on it on the day of trial. It had been served the day before trial. And at paragraph 7 of this judgment, on page 52 of the bundle, Lord Justice Longmore approved the approach taken by the first instance judge, which was to treat the application as an application for relief from sanction. Albeit if you look at paragraph 7, it appears as though that was based on based on notes in the White Book rather than 35.13 itself. And at paragraph 11 of this decision, on page 53, the court will note that His Lordship went on to give a general warning about the court's decreasing tolerance of the failure to serve expert evidence in accordance with previous orders of the court. Another example which does refer expressly to Rule 35.13 is the case of McGee and Wilmot, 2020 England and Wales High Court, page 1378, which Milady and the Laws will find at page 98 of this bundle. In that case, a judge at first instance granted permission to the claimant to rely on expert evidence that was served out of time, and the defendant appealed. And if one looks at paragraph 24 on page 103 of the bundle, it can be seen that Mrs. Justice Yip said the recorder had been correct to hold that 35.13 was engaged and the claimant required relief from sanction because the report had not been served in time. In the event, the judge disagreed with the conclusion that granted and the decision was set aside, but I won't trouble my lady in court with the reasons why. In the present case, if the claimant had applied for and been granted permission to rely on a pain management report at the CMC in October 2020, as we say he ought to have done if he was going to go down that road, then there can be little doubt he would have been ordered to serve it in accordance with the other directions by in or about March of 2021, along with the other expert evidence, or at least shortly after that, and certainly well in advance of the pre-trial settlement hearing, which was listed for November of 2021. If he then failed to do that, and had not served the report until February of 2022 and applied for permission to rely, there can be no doubt he would have required relief from sanction. And he would have been at a more advanced stage then as well, because he would have had the report. If I can now refer back to paragraph 9 of FXF to deal with the second category of case. It's at page 19 of the bundle. We dealt with the first category of case. The second category of case is one where the rule does not expressly state the sanction which applies to the non-compliance, but the permission of the court is needed to proceed. And an example is given of a failure to file a notice of appeal on time. Again, in the context of expert evidence, an example of an implied sanction is the decision of the Court of Appeal in Elliott and Stobart Group, 2015, England and Wales Court of Appeal Civil 449, which is at page 63 of this bundle. Now, in this case, the defendant had been ordered to serve a psychiatric report in support of his claim he had suffered a mental disorder or exacerbation of a mental disorder due to an injunction which the claimant had obtained, preventing him from making defamatory statements. When the injunction was obtained, the claimant gave a cross-undertaking in damages, and the defendant was alleging that he was entitled to damages because of the mental disorder that he had suffered as a result. And the order made by the judge at first instance can be found summarised at paragraphs 23 and 24, which is on page 69 of the bundle. The defendant didn't actually attend the hearing when the order was made, and he was given 10 days to apply in writing to vary or discharge it, which he didn't do. And he then failed to serve a psychiatric report on time in accordance with the orders that had been made. And in fact, he didn't do so until the day before the next hearing, when he then made an application for an extension of time for service. And paragraph 32 of this judgment on page 74 of the bundle, and this is the judgment of Lord Justice Tomlinson. We can see at paragraph 32 it's recorded. The judge at first instance treated the application as an application for relief from sanction, and that was then dealt with by Lord Justice Tomlinson at paragraph 43, which is on page 81 of this bundle. The court said this: In my judgment, Judge Platts was correct to treat this as a case in which the order of Judge Pelling by implication imposed a sanction for non-compliance. Here, the inability to proceed with the claim for compensation under the cross undertaking. And he then referred to Altamart, which is, of course, a case on implied sanctions. He went on to say, the tide is flowing strongly in that direction and towards a less indulgent approach to non-compliance.
Mr. Whittle, can you help me with this on Elliot? The thing I don't understand about Elliot is why it was called implied sanction. Why there was
I was going to make that very observation, but one of the things I don't understand about this case is why the court didn't refer to 35.13, because 35.13 is engaged.
Well, I wasn't going to mention that, actually. I was going to ask about paragraph 10 of the order that was made by Judge Pelling. Which says if the defendant does not file it in accordance with the order and does not make an application, then certain consequences will happen, which, at least as far as I can see, is an express sanction.
Except it's only that the claimant would have permission to apply, so maybe it's
Well,
quite tough enough.
Well,
yeah, I'm not sure.
It does look like an express sanction to me.
No, well, I think it wasn't an unless order. It wasn't unless the claimant files a psychiatric report by X date, he's debarred from relying upon it.
Yes,
It was the claimant must file the psychiatric report by a certain date. Because he didn't turn up, he was then given permission to apply to vary the order.
Yes, I understand.
But I don't. The order that was breached does not contain an express sanction.
Well, the order that was breached is the order set out in paragraph 24. It's the order. It's the order at para 1, 23 and 24. That's the order.
Yes.
That's the order he was required to do something and didn't do it.
Yes.
And that order at paragraph 10 contains a statement of a consequence which happens if you breach the order. And I do take my lord's point. I do that it's not a very might be thought analytically not to be a very severe sanction because it's just permission for the other party to apply to strike something out, which is just a permission to apply. But it is, seems to me, a consequence, and I don't understand why.
Yes, but the consequence, because if you think about the relief from sanctions analysis, in that case of the helpful case of Lufthansa, which we were asked to look at, when the sanction takes effect, according to the order. Now, if you look at this order, the sanction doesn't take effect when if the claimant doesn't make an application. At least according to this order allows the claimants to apply to strike out the claim, which envisages that it's a bit like default judgment, that if you don't enter a defence in time, then if the claimant asks the judgment, then there'll be default judgment entered, and then an application for relief from sanction has to be made once default judgment has been entered. And I think that's what this is getting at.
So just make sure I understood your submission. Your submission is that this paragraph is not a sanction.
Well, no, I'm not going to say that because I haven't actually turned my attention to it. So, in fairness, I simply focused, possibly wrongly, on.
No, I'm not saying.
No.
I'm trying to understand all this.
Yeah, I don't say it wasn't. I suppose what I was using this case to demonstrate is simply an example in the context of expert evidence of an implied sanction, nothing more than that. And I was going to make the observation that it seemed to me that perhaps it wasn't drawn to the court's attention that 35.13 exists, just like it doesn't appear to have been drawn to the court's attention in Boyle that 35.13 exists. But it does, and in my submission, it's 35.13, the express sanction, which applies if you don't serve your expert's report on time and you don't make a prospective application. That point seems to be confused under these cases. But in my submission,
what I'm puzzled about as well is that in 43, Lord Justice Tomlinson is saying that it's by implication imposing a sanction. The sanction he identifies is an inability to proceed with the claim.
yes.
And speaking for myself right now, it's not obvious to me what the source of that inability is, even by implication.
I think what his lordship probably had in mind was that, absent a psychiatric report, the claimant's claim that he'd suffered a psychiatric disorder was bound to fail.
Right.
I think that's what he's getting.
Well, that's obviously what the para 10 was getting at as well.
Yeah.
Okay.
Anyway, look, perhaps it shouldn't be a case of a sanction by implication, but it just illustrates it shows it's one illustration of that sanctions can be implied. And I picked it out simply because it's a Court of Appeal decision on expert evidence, and it just didn't feel right to me to come to this court without referring to this case when it's a Court of Appeal decision on relief from sanction which deals with expert evidence. Anyway, perhaps a better example than this one, is MS a Child and Croydon Health Service NHS Trust. And I don't pretend this is a brilliant case, because it's where the parties agreed that relief from sanction applies, but it's still useful to look at in my submission. This can be found at page 113 of the authorities bundle. And the reference is 2020 England and Wales Court, page 2728. And the key facts of this case are summarised in paragraph 6 on page 114, albeit I ought to add as a health warning that there's a typo in the first line when it says on the 7th. If you read the first two sentences, you'll be confused. 7th of May 2020 should be 7th of May of 2019, which is apparent if you look at in the third line of paragraph 2. So this was a clinical negligence case. What happened was there was a CCMC in May 2019. The claimant asked for permission to rely on various experts' reports, but also said, look, there are a number of reports in other disciplines which we might want to rely upon, but we don't know yet, and can't make that decision. But we're just letting you know so that you're aware when setting the timetable, this is something that we may do. And the court said, right, well, on that basis, we'll set a date by which the application for permission in those reserved disciplines had to be made. And the date for the application for the reserved disciplines was January of 2020. And there's nothing to indicate that the order that was made in that regard was an unless order. It was just the claimant shall make any application to rely on these other reports by January of 2020. So what happened was the claimant didn't make an application, but instead served reports from 4 experts in the reserved disciplines at that time, along with the other expert evidence. And the defendant took the point that no application had been made for permission, and the parties agreed that CPR 3.9 applied to the claimant's application. And one can see from paragraph 14 of this decision on page 116 of the bundle that Mr. Justice Goose applied 3.9 without demur. And in my submission, the reason he did so is his lordship accepted that when the claimant was ordered to make her application for permission for further experts' reports, there was an implied sanction that if it was not made by that date, the claimant would not be able to pursue it unless the court granted an extension. And I submit that was a perfectly proper and correct approach to take, because it's obviously good practice for a party who thinks he might need to rely on an expert but hasn't made his mind up and wants to wait to see how the evidence unfolds, to tell the court that's what he's thinking, so the court can then build that into the timetable so it's not disrupted later on. And that in my submission, is all part of case planning, particularly in the bigger personal injury work, the catastrophic work, where it's often the case that before one of the masters, we'll turn up and there'll be a dispute about whether care evidence is needed, accommodation, that kind of thing, what I would call the non-medical expert evidence. And the master will order the parties to finalise their core medical evidence and see what the experts say before then listing another CMC to decide whether or not there should be permission for additional expert evidence. That's all vital to the efficient conduct of a case, court listing, etc. And in my submission, if a party doesn't bother to plan a case, doesn't bother to tell the court that he's thinking about making an application for expert evidence or might want to do so in future, then he isn't in a better position at a much later date when he makes the application than the party who does tell the court and finds himself the subject of an order which sets a date by which the application has to be made. In my submission, in either circumstance, the party is subject to the Denton test, and that's because, regardless of what any order says, 29.4 and the practice direction to Part 29 lay down rules as to when an application for expert evidence must be made. In my submission, that's by the CMC at the latest. If the court doesn't order at that hearing that an application for expert evidence can be made at a later date, then for reasons I'm going to explain shortly, it has to be made at that hearing. And if it isn't, the default position is an extension of time is required to make it. And without that extension, the party can't rely on the expert evidence. In my submission, an application for, or an order rather, allowing an application for expert evidence to be made at a later date is simply granting an extension of time that the rules say should be made at the CMC.
And so you would say the MS case, where the parties were alive to the possibilities of needing further experts, depending on how things bottomed out, and therefore the court made an order, is in fact no different from a situation in which nothing is said at all, because the rules require you say, to spill the beans at the CMC, one way or another, and therefore, because you haven't, and therefore you have no order against you, you should be in no better position than if you had been candid or organised.
With one caveat. With one caveat to that, my lady, which is Practice Direction 29, paragraph 6.4, which is also, it reflects the decision of the Court of Appeal in Tibbles and SIG, the judgment of Lord Justice Ricks, in the case where if you make an application and it's refused, you can't then ask the court to vary or revoke that decision unless there's a material change in circumstances, and that's embodied in Practice Direction 29, paragraph 6.4. And in that case, the Court of Appeal recognised there might also be cases where at a CMC you might forget to do something, and then you've got a short window in which to correct it. But in my submission, if you know, if the prompt for the application is already available and before you and known before the CMC, then the rules require you to make the application at the CMC. Parties can't just make applications for expert evidence as and when they like. They are required to do so at the CMC, assuming that there is some basis for doing so. If there's a change, for example, it might be that following a CMC, a report is received which highlights a completely different cause for claimant's symptoms, which no one has thought about before, or the claimant develops some complication in his recovery, which necessitates another expert report. That might be different, I accept that, because of PD 29, paragraph 6.4. But if there's no factor of that nature, and if all it is, well, I didn't think about it, or, well, I thought about it, but I thought differently at that time, I've changed my mind, well, that's not good enough in my submission. If that's the situation, the reality is you need an extension of time to do what you should have done at the CMC. And I'm going to develop that submission in relation to the facts of this case in a moment. And before I do that, can I then just go back to FXF and deal with the third category, please? Again, if it's back to, we're back to page 19 of the authorities bundle, paragraph 59. The third category is cases where a further step is taken in consequence of the non-compliance, such as the entry of a default judgment or the striking out of a claim for non-attendance at trial. And my lady and my lords have seen already from paragraph 65 that Sir Geoffrey Voss recognised that the third category wasn't strictly within 3.8, but nonetheless felt that the Denton test should apply. And I'm going to suggest one modification to that, if I may, and it's this. This category should encompass a case where there's a breach resulting in a sanction, however imposed. In other words, whether it's due to a step taken by the court or it arises automatically from the rules themselves. And in the context of this case, I submit a failure to ask for permission to rely on an expert's report at the time set by the rules, the practice direction, or by an order of the court results in a sanction, namely the inability to rely on the expert's report because of the provisions of CPR 35.41. 35.41 is on page 293 of the authorities bundle. It provides no party may call an expert or put in evidence an expert's report without the court's permission.
My problem with your submission, Mr. McLaughlin, is that you seem to be making that paragraph a sanction.
My lord,
it's not, is it? I mean, it isn't a sanction.
Well, may I make the submission? If
yes.
a party fails to ask for permission to rely on an expert's report in time, the result is this provision operates as a sanction. It is the sanction for not asking. And again, I will develop that.
Just so you understand where I'm thinking, if you want to say anything about it. If that's right, why isn't that also the case when you're making the application at the CMC for the permission you need?
Because, my lord, the obvious answer to that is that when you make the application at the CMC, you're not in breach of anything, are you? The Denton analysis requires a breach resulting in a sanction and the need for a retrospective application. So it's not an answer to say, in response to my analysis, that my submission means that you need to apply for relief from sanction at the CMC. No, you don't.
No, why?
Because you're not in breach.
Yes.
So that's not an answer.
So what are you in breach of in the example you're now giving us?
Well, what you're in breach of are the things I've identified, the list I've identified. You're in breach of those provisions.
I see.
And this operates as a sanction. This is the third category. The third category is there's a breach, and the court have said, well, the Denton analysis will apply if the sanction results from a judgment rather than it being in the rule itself. All I'm doing is saying, right, okay, that's fine. It shouldn't just be limited to if the court takes a step. If you're in breach and as a result of a different rule rather than necessarily a court order, then that rule imposes a sanction or operates as a sanction, which is what it does, then there's no justification for a different approach. This is a sanction. It is the sanction for not asking. And I'm going to develop that argument by reference to the facts of this case and the orders made. Before I do that, obviously I need to deal briefly with the reasons why permission to appeal was granted in this case in the first place, and that's the conflicting cases. And I'll just do that shortly.
On your analysis then, the day after the CMC, nobody knows whether the claimant is in breach for not asking. You only know that 6 months later when they do ask for something, which has just occurred to them, and you say, oh, well, it turns out, although you didn't know that, and we didn't know that because we didn't know you were going to ask, you've been in breach for the last 6 months.
Well, you're deemed to be in breach.
Well, you're either in breach or you're not.
Well,
there's nothing in the rules.
Well, you are.
There's nothing in the rules about being deemed to be in breach.
You are in breach, but what does it matter if no one knows? What does it matter? My answer to that is, well, so what?
You may never ask.
Well, in that case, it won't be an issue.
Yeah, but
you
only know, on your analysis, you only know that someone is in breach when 6 months later they ask for something.
They make an application. Yes, but I accept that. However, in my submission, it doesn't matter if you only know. The fact that neither party is aware that there has been a breach at that stage, in my submission, should not affect the application of the. Doesn't affect the fact that the application has not been made when it should have been made.
And is it not a little more complex than that, because you don't know until they ask, but B, you don't know even when they ask, unless I'm just
yes
postulating, unless you then at that stage when they do ask and analyse the situation at the CMC in order to determine whether this is something which they knew or ought to have known.
Yeah.
And I put that as broadly as that, ought to have known, that they ought to have been talking about, at least, because you put it as wide as that, not just asking for permission, but telling the court that it might be in their blue sky thinking something which might be relevant, and then the court would give them a deadline for dealing with it. So you don't even know whether you've got a breach until they ask. When they do ask, you've then got to go into that analysis of what was known or ought to have been known at the date of the CMC. Is that right?
But you've got to do that anyway, because of the assumption in Practice Direction 29, paragraph 6.22. The court starts from the assumption on any later application that the order that was made at the CMC was correct, and that means not only that it was correct, but it was complete. So one can't say as an objection, well, it's irrelevant why it's not being made until now. It wasn't raised before, we shouldn't explore that. Of course it's got to be explored, because if it's not explored, how on earth are, for example, paragraph F of 1.1 engaged, or proportionality? If you're looking, if we're going to say that proportionality, efficient conduct of litigation, etc., are now at the forefront of procedural justice, then clearly an analysis of why the application was not made before is necessary. In fact, that's necessary even under the T-test, T and Imperial. One looks at T and Imperial, and I'm going to do that shortly. One of the things that, the first thing that's got to be considered is, well, is there a good explanation for the application? So I don't see that as an objection to my analysis. It's got to be done anyway.
Can I just put something to you, Mr. McLaughlin?
Yes, of course.
The sort of retrospective breach idea, the idea that you only find out later that you're in breach, at least speaking for myself, it feels a bit like a situation where you just take considering experts' witness statements. So you have a deadline for witness statements, and let's say the party serves one witness statement.
Yes.
So it complies with the order as far as that witness statement is concerned. But then 2 weeks later, tries to serve another witness statement, a different one, a different witness.
Yeah.
In fact, that witness statement, they are in fact in breach, because that witness statement should have been served 2 weeks earlier. But you only find out when they produce the second witness statement.
Yeah.
At the time of the order, when the date happened, on the face of it, they're complying with the order.
Yeah. And the same goes
what I'm
actually.
trying to put it to you is that it's not as.
Not as well, thank you for that. I accept that. And perhaps sort of, I think that I said in response to my Lord's point, it doesn't matter, and I don't think it does. I mean, what matters is whether there's a breach, not whether anybody knows about it, because you only deal with the application for relief from sanction when the application is made, and when the application is made, you then know, or you can work out whether there was a breach. The fact you might not know earlier in my submission is neither here nor there, because all the decision is being made on the application. So I submit that it doesn't matter that you don't know if there was a breach, and the fact you have to then, when you're dealing with the application, look back and to find out whether or not there is a good explanation for the failure to make it earlier is an exercise that is required whether you apply Denton or T Imperial. So the fact you have to do that, again, is not an objection to my analysis. And I would submit this, that if you make the application later, you can't be in the same position as you would be if you'd made it when you should have done at the CMC. I mean, the rules say you're supposed to ask for directions at the CMC, or if you make it a lot later, close to trial, you threw a hand grenade effectively into the conduct of litigation. You can't then say, well, we're in the same position now as we would have been at the CMC. There has to be a much stricter approach. If the application should have been made earlier, absent any material change in circumstances, in my submission there can be no logical objection to the relief from sanctions analysis.
And the situation which is slightly stronger for you is, why should you be in a better position if you do nothing and then apply at the last minute, in comparison with the party who at the CMC says, but we don't know whether we're going to need X, Y, and Z, and the master or the district judge says, okay, if you want to do any of those things, this is the deadline.
Yeah.
And then they're in a position that they would have to apply for an extension.
And one of the biggest causes of disruption to cases is the lack of planning at the CMC. It's that the claimant issues a claim with an incomplete schedule of loss, a GP's report or an old orthopaedic report on the basis of marks in universal coatings, and said, oh, well, we're not in breach of anything because we've served out some evidence, and then turns up at the CMC and demands a raft of experts' reports, all to be exchanged in due course. No one really knows where the case is going, either because the evidence hasn't been obtained or it has been obtained but they don't want to disclose it for tactical reasons. We don't know what the case is genuinely worth, and as a consequence the case drags on for months, and then there's a late application that just causes even more problems. So it must be the reason that you should, if there's a policy reason to support all of this, it's to support proper case planning, to get parties to think about what expert evidence they need at the right time, which must be at an early stage.
But you don't need relief from sanctions for that, do you? You can simply say that if what somebody's doing amounts, as you describe it, to throwing a hand grenade into the proceedings, then they're not going to get permission anyway.
Well, I would have thought that is the case, my lord, and if I'd won at first instance, which is the submission I made, then we wouldn't be here now. But apparently not, at least not in the minds of the judges below. Anyway, if I can then move on from, I think I ought to look briefly at the cases below, the conflicting decisions of the High Court on this issue, because that was the reason permission was granted. I don't think this will take very long. The first case is S.J. Moore Jeweller Limited and Squibb Group, which is 2018 England and Wales High Court 2731, and that starts at page 38 of the authority's bundle. So this is a decision of Karen Stain, Queen's Counsel, sitting as a Deputy High Court judge. Her ladyship found that the Denton test did apply, and the relevant part of her decision is at paragraph 46, which is on page 45 of this bundle. And perhaps if I could ask my lady and my lords just to read paragraphs 46 down to 50 and then 52.
52.
Yes, 46 to 50 and then 52.
Thank you.
Mr. McLaughlin, what order or what order, rule, or PD was breached?
Well, my lord, that's a good question. I was just going to, in commenting on this decision, first of all, I was going to make the point that her ladyship was alive to the case of Jones and Owen, and she obviously had sympathy with the decision in that case. She noted that there was a distinction between the facts of it and the facts of the case before her, because in Jones, it was impossible for the parties to know in advance that further evidence was going to be required. And she acknowledged that that's a different category, and that harks back to what I said a moment ago. In the present case, on the facts before her, she felt there was no good reason for the lateness of the request, and I just say in parenthesis, you'll see that from paragraphs 57 and 59, and it's against that background that she made the comments she did at paragraph 50. And my lord is right that her ladyship did not actually identify the particular rule or practice direction that was breached, but in my submission, she clearly had that in mind.
Well, I wonder, if you look at paragraph 50, she says the parties were required to identify any need for expert evidence in their directions questionnaire, identifying the field and giving a summary of the justification. So it looks as though she may have regarded that as, in effect, an order.
It was. Oh, I see. Right, forgive me.
You've got to tell us by the CMC what expert you
The way I read it was, because obviously what happens is the directions questionnaires are usually sent out without an order of the court. Normally, you file the pleadings, the defence then triggers the DQs being sent to both parties, and you fill them in.
But is there an order or a rule that says you must complete the directions questionnaire?
I'm not. I think it's just a provision that the parties have to do so as part of. It's part of a compliance with CPR 29.4 and 29.6. So the point is, she had in mind the point I'm making, that you can't just apply as and when you want. You've got to apply in accordance with the rules. She cross-references the directions questionnaires, but she clearly had in mind, Part 29 and the practice direction, that you have to make your application before the CMC. That's what she's saying. And if you look at 52, you can see that she was guided by the commentary at paragraph 35.5.1 of the White Book, where it says the courts have emphasised it will not normally be acceptable for expert evidence to be served late, particularly so close to the start of the trial window. And that guidance hasn't changed, except you'll now find it at note 35.0.2, which is at page 1111 of volume 1 of the latest edition of the White Book.
So it's now
35.0.2, page 1111 of volume 1, 2023 White Book. It's the same.
The rule on directions questionnaires is 26.4, and it does operate as the court officer sends out a notice of provision allocation, which requires you to fill in various things, including the directions questionnaire. So you are required to do it.
Yes, thank you very much, my lord. In a similar vein to this case, I can ask my lady and my lords to look at Global Energy Horizons. That's at page 84 of this bundle. And the reference to the case is 2019 England Wales High Court 1132. The context here was that Mr. Justice Arnold had to decide whether to allow an application to rely on a supplementary report from an existing expert in the case, and he had to decide whether that should be subject to the Denton test. There'd been no direction for supplementary reports at the CMC. If one looks at page 94 of the bundle, paragraph 31, again, if I could just ask the lady and the laws to read 31 and 32.
Mr. Justice Arnold, as he then was, makes the distinction in 32 that it depends whether the matters are new or not.
Yes, that's the point. So I infer that what his lordship had in mind was the rules require the application to be made when directions are given, save where it's prompted by a change in circumstances. Finally, I come to the decision which was applied below. That's the decision of Mr. Justice Stewart.
Just forgive me. Do you say that this particular analysis is as written here is correct or not?
Well, what his lordship has said is that he's referred to the deadline for exchange of expert evidence as being the breach, effectively. I submit that actually the breach was at an earlier stage. The breach was the failure to ask the Commission to rely on a supplementary report when directions were given. That's the breach. If I'm wrong about that, then obviously I adopt what he said about breach being the deadline for service of experts' reports.
But do you support the idea that whether circumstances amount to relief from sanction depends on the circumstances?
I accept, despite my skeleton argument, having reflected on it, I accept that when you look at Practice Direction 29, paragraph 6.4, that it seems to envisage that a change in circumstances might take you outside the Denton test. The way I...
Oh, I see. So you say, what you're putting it in my terms, this analysis might be right if it had been based on those rules.
Yeah, absolutely, yeah. Yes, absolutely. So if I can now then just go to, again, look briefly at T, a child and imperial. This can be found at page 23 of the authorities bundle. The reference is 2020, England and Wales High Court, page 1147. It's a clinical negligence case in which Mr. Justice Stewart disagreed with the decision of Cameron Stain, QC. The reasons he did so can be found on page 31 of the bundle at paragraph 22. And also paragraph 23. If one looks at the factual context in which these comments were made, one can rather understand why he took the approach he did. If one looks at paragraph 4 of the judgment on page 25, my lady in the Lords will see there's a summary of the procedural history, and one can see that the parties agreed directions which were given in November of 2018, and the trial was listed in April of 2020. See that from the bottom of paragraph 4. And then turning over, we can see that the expert joint statements were due to be completed by October of 2019. And then out of the blue, one sees from paragraph 5, the defendant's neurologist produced a letter in December of 2019 in which he said, well, genetic factors may well be playing a part in causing the claimant's disabilities. And one can see from paragraph 7 on the same page that Dr. Rosenblum recommended the instruction of an expert in clinical genetics. So the case that the judge was dealing with was one where the application was based upon what appeared to be a new development in the expert evidence which hadn't been anticipated hitherto. In other words, it was potentially a material change in circumstances. It's fair to say that that was disputed by the claimant, but anyway, that was the basis upon which the application was made, and that may have influenced the approach that the judge took. But if one then turns back to paragraphs 22 and 23, what I submit is notable from these paragraphs is there's no discussion at all of whether the defendant was in breach of any rule, practice, direction or court order.
It's treated as a case of no sanction
Absolutely.
rather than no breach.
The judge is taken to 35.4, but not apparently to any other rules. And I don't blame him then in those circumstances for just if you just look at 35.4, then you're not going to conclude that the Denton analysis applies because 35.4 doesn't say anything about the timing of when an application should be made. 35.4 simply says, well, you can't rely upon an expert report unless the court gives permission. It doesn't say, well, and you must make your application by the CMC or anything about it. If you just apply 35.4, then timing is irrelevant. So it would be easier to understand what the judge said in my submission if he'd said, well, 35.4 doesn't say anything about when an application has to be made, rather than him saying, well, it doesn't contain a sanction. In my submission, with great respect to the judge, and I recognise he's a highly eminent former personal injury practitioner and personal injury judge, and I recognise that he had a senior counsel in front of him, but in my submission, to say it doesn't impose or it doesn't contain a sanction is just wrong. It operates as a sanction if you don't ask in time. The first question that he had to ask, and that he should have been invited to ask, was there a breach of a rule, practice, direction and court order? If he'd been asked that question, then we would have seen, no doubt, an analysis of whether there was a breach, and then following on from that, if there was a breach, and only if there was a breach, then the issue of whether 35.41 operated as a sanction. So that's my criticism of T and Imperial, and why that in terms of guidance or help, that the court should be cautious before adopting it. And I'm pleased to say that I can now turn.
So do you have a submission as to whether he should have held that there was a breach?
Well, yes, absolutely. It's what I'm turning to now. That an order was made for directions, and we can see that what directions were given, and there was no request for permission to rely upon a clinical geneticist. If the claimant was right, and the defendant should have been thinking about it, then there was a breach. But if in fact it was a material change in circumstances, then maybe there wasn't. I say maybe because obviously my skeleton argument has submitted that the Denton analysis should apply in all circumstances, and part of the reason for that is that the Denton analysis is not some kind of doomsday test. It has a degree of flexibility. If there is a material change in circumstances at stage 2, applying Lord Dyson's analysis in Mitchell and Denton, he said a change in circumstances is a good explanation for allowing relief from sanction. You potentially don't even get to stage 3. So adopting the Denton test is not going to result in unfairness to people who find there's a change in circumstances and realise they need to apply for additional expert evidence. If there is a genuine change, then they've got a good explanation under stage 2, in which case the application shouldn't be opposed, applying Denton. Anyway, perhaps whilst my Lords and Malia are thinking about it, can I turn to the facts of this case and the appeal? Because my submissions, or the key submissions, are really now on what the breaches were and what the sanction was as a result. So one has to approach this, first of all, step by step. I appreciate it might be easy when I outline the breaches to jump and say, well, what's the sanction? But can I leave that to the second stage? The first question is whether the claimant's failure to apply for permission to rely on a claim management report and to seek a direction to that effect and to serve it via a date determined was a breach. And in my submission it was. And these are the breaches. First, the court listed the matter for a CMC by virtue of its order of the 3rd of August of 2020, which is at page 14A of the supplementary bundle. And I've asked that to be turned up. One can see from this the order's drawn on the 15th of August but actually made on the 3rd of August, and it contains the heading or the warning that you must comply, otherwise your case is liable to be struck out with some other sanction imposed, etc. The claim was allocated to the multi-track, and then the usual orders for contact, sending of documents, etc. And then over the page there's a heading Costs and Case Management Conference, when there's an order for it to be listed. And one can see from paragraph 7C, the CCMC has been listed for further active case management, including the making of a cost management order and finalising directions. And D, there's a warning about the listing of a PTSH. And then at F, the parties must have dates of availability for all witnesses, including expert witnesses, that they intend to call or seek permission to call to give evidence. That meant that in my submission the parties were required to turn up and to make applications for such expert evidence as they wish to rely upon and to provide the expert's details so the court could then fix the matter for trial. In addition to that, if one then puts that bundle to one side, we then move on to the next provision on which I rely, and it's paragraph 29.4, which can be found at page 288 of the authorities bundle. Under the heading Steps Taken by the parties must endeavour to agree appropriate directions for the management of the proceedings and submit agreed directions or their respective proposals to the court at least 7 days before any case management conference. That means a party wanting to rely on expert evidence is required by this rule either to agree the expert evidence that's required with the other party, or at least to submit a direction as to what expert evidence is required, and to do so within the time limit set by the rule, namely 7 days before the hearing. One then turns to Practice Direction 29, please, on page 298 of the bundle. I could ask my lady and my lord to look at page 299, paragraph 3.5. Under the heading Case Management General Provisions. It says this: when any hearing has been fixed, it is the duty of the parties to consider what directions the court should be asked to give and to make any application that may be appropriate to be dealt with then. And I emphasise the words, to be dealt with then.
I'm sorry, I was behind, so I'm on page 299. And
Paragraph 3.5. I'm so sorry.
Brilliant. No, that's fine. Got it. Thank you.
And if one then turns to paragraph 4.7, this is directions on allocation. It says to obtain the court's approval, the agreed directions must at D include provision about both factual and expert evidence. And then moving on from that, paragraph 5.6.
The agreed directions in this case?
Well, that's something that caught my eye momentarily, and I actually don't know what the agreed directions. But if I can move on from that to page 302, paragraph 5.3. This is not a breach, but this is just something this is highlighting to the party. It's the context of the breach that I'm about to refer to. Paragraph 5.3 explains the topics the court will consider at a CMC are likely to include, and at 4, what expert evidence is reasonably required, and how and when that evidence should be obtained and disclosed. Now, that's not a breach, that's just telling you what you've got to think about. But if then one looks at 5.6, it says to assist the court, the parties and their legal advisors should, in item 4, consider what orders each wishes to be made and give notice of them to the other parties. That includes, obviously, in relation to expert evidence. And then reading further down, 6.21, 6.1 says this paragraph deals with the procedure to be adopted where a party is dissatisfied or where they've agreed changes or where a party wishes to apply to vary a direction. 6.21, it's essential any party who wishes to have a direction varied takes steps to do so as soon as possible. And at 6.62, the court will assume for the purposes of any later application, the party who did not appeal and who made no application to vary within 14 days of service of the order containing directions was content in these circumstances then existing. So, just pausing there momentarily, in my submission, the failure by the 12th of October of 2020, 7 days before the hearing, to submit a proposed direction for permission to rely on a pain management report was a breach of Rule 29.4. The failure to bring dates of availability of a pain management expert and to request permission to rely on a report was also a breach of paragraph 7F of the order of the 3rd of August. The failure to apply to rely on a pain management report at the CNC on the 19th of October was a breach of paragraphs 3.5 and 5.6 of the practice direction. That's practice direction 29. The claimant was in possession of the 2nd and 3rd reports of Mr. Quayle, the orthopaedic surgeon, which date from April of 2019 and the beginning of September of 2020. I'm assuming that my lords have seen those, and those contain recommendations that the claimant be seen by an expert in chronic pain management, so I won't waste time going into those. Mr. Jennings, the claimant's solicitor, admitted in the witness statement that he filed in support of the application made in February of 2022 that it was that evidence that prompted the application to rely on a pain management report, and the admission effectively is contained in paragraph 11 of his statement on page 9 of the supplementary bundle. Again, I don't think there's any need to refer to that now. If it's in dispute, no doubt we can do that in due course. So, just pausing there, in my submission, given the existence of those two reports and Mr. Jennings' evidence, the claimant simply cannot be heard to say that it wasn't a breach of the order of the 3rd of August, or Rule 29.4, or the paragraphs of the practice direction that I've identified, to omit to ask for a pain management report at the CMC.
Have those reports gone to the other party?
We've got the reports of Quayle by the date of that hearing, I think, yes. Yeah.
Quayle 3, the one that...
If he wanted, because if you look at the order, he gave permission for all three reports.
Yes, it refers to all three.
Yes, we got all three. If he wanted to rely on a pain management report, in my submission, he was duty bound by each of those provisions that I've identified and the order of the court to tell the defendant and the court that was what he wanted to do and to make the application then. And it isn't an answer to say, well, at that stage, he didn't want to rely on a pain management report, and so there was no breach, but later he changed his mind. There was no material change in circumstances between the 3rd of August, the 19th of October, and the February of 2022, when he eventually made the application. And accordingly, I submit that when making the application, what the claimant had to do was to seek and obtain a retrospective extension of time to comply with the provisions that he had breached. He also had to seek a retrospective extension for failing to act as soon as possible as required by 6.21 of Practice Direction 29. The court will have seen that there was a pre-trial settlement hearing, a very important hearing, on the 1st of November.
Which was it? You said failure to act as soon as possible in accordance with what?
In accordance with Practice Direction 29, paragraph 6.21, which provides it is essential any party who wishes to have a direction varied takes steps to do so as soon as possible. He was in breach of that provision because he did not take steps to do so as soon as possible. There was a pre-trial settlement hearing on the 1st of November attended by myself and counsel for the claimant, not, I emphasise, Mr. Pressman or Mr. Chapman, but somebody else. The court dealt with a mediation between the parties to see if the matter could be resolved, and it then went on to consider the issue of what all expert evidence was required. And the order specified that there would be all evidence from the orthopaedic experts. Nothing was said at that hearing about pain management evidence. And that was 4 months before the application was made. And the court should also note that paragraph 11 of the order of the 19th of October, which is on page 16 of the supplementary bundle, actually set a date for when the parties had to make their application for all expert evidence. And that date was the 15th of October of 2021. It says the parties shall file pre-trial checklists by 4 p.m. on 15th October, which shall accompany any application for leave to rely on all expert evidence at trial. The claimant was in breach of that direction for failing to apply for permission to rely on evidence from a pain management expert. That should have been done in my submission. And I rely upon each and every one of these breaches. I appreciate there might be a temptation to try and pin me down on one or other, but I rely on all or any of them in support of the proposition that the claimant was in breach of a rule, practice, direction or court order in answer to the first question as to whether or not the relief from sanction analysis should apply. So, moving to the second stage, acting on the assumption the claimant was in breach of any or each of those provisions, the second question is whether there was a sanction as a result. And I accept that none of the provisions I've identified contain an express sanction in the sense that they don't contain an unless order, as envisaged by perhaps the first category of FXF. But in my submission, that doesn't matter. And I contend there was an implied sanction in each or any of these provisions and the orders that if an application was not made by or before the CCMC, or at the very latest by the PTSH, then the claimant would not be able to make an application to rely on expert evidence and would not be able to rely on expert evidence.
We don't, sorry, still on breaches. We don't see in either of the judgments below any analysis of the breaches on which you're now relying. Were these all argued before the judge and the district judge?
Well, the relief from sanctions analysis was certainly argued before.
Yes, certainly,
And
but
I'm just looking at my...
breach of these particular orders and breach of the...
Well, certainly I argue below that the...
in CPR 29 and the practice direction, and there's just no mention of them in either judgment.
No, but I did set out that there was my skeleton argument, but my skeleton argument below is on page 104 of the core bundle. When I referred to the fact that they got Mr. Quayle's reports, and I refer, for example, in paragraph 5 about the fact that there was permission to for the orthopaedic experts to give all evidence at trial, and that no other direction for expert evidence was sought. I mean that sets out that the basis from which I made the submissions below. It's fair to say it probably doesn't contain a specific reference to CPR 29 or the practice direction, but this is an appeal.
Can I just say, if it assists, I didn't appear at that hearing, but my learned junior did. He doesn't recall the practice direction of Part 29 being argued.
We may not have
checking the
looked.
skeleton argument.
I think it was probably assumed that you are supposed to, the submission was, you are supposed to ask for permission at the CCMC without there being direct reference to the orders or the practice direction, because that was the approach that seems to have been taken in the various cases.
And you went through the cases, if you look
I
at
went through all the
paragraph
cases.
10 onward, and then at 11, you say there's no legitimate distinction between a case where a claimant is granted permission to serve an expert's report, but does not serve it in time, and where he omits to seek permission, etc. So it's you'd say that is the territory, at least.
I mean, in fairness, I think it was Lord Justice Lewison's grant of permission that maybe prompted me to look closer at the practice direction to Part 29. But this is an appeal on a point of law based on uncontested facts. I mean, these facts are not contested. So even if a point of law isn't argued below on, if facts are uncontestable, which they are here, because the orders that are made and the practice directions made aren't in dispute, well then it doesn't matter if it wasn't argued below. I'm entitled to take points of law, pure points of law, above, even if they're not taken below. So if I then go back to, I was going to...
I follow that, but it's a matter of perhaps fairness to the judge.
Of course, look, absolutely.
Looking at his judgment to know what was argued and what wasn't.
I absolutely accept that, and may I say that if you just look at the case law, none of the case law provides a particularly clear answer to this question. There are conflicting authorities. When you read the authorities themselves, sometimes you're scratching your head, you're saying, well, what's he meant in that for and not something else? Then, of course, it's not going to be that straightforward for the judge to deal with it. So I entirely accept that this is a difficult case. It was a difficult case before the judge, and it's a difficult case to present. So anyway, moving it...
Sorry, Mr. McLaughlin, just while it's fresh in my mind, if you want to come back to it, feel free. One thing that's troubling me a little at the moment is I understand the submission that you make looking at all these Rule 29 and PD 29. You say, look, here are all sorts of provisions which you say have been breached, and therefore there's a breach, and therefore you say the permission criteria that you're coming to tell us, you foreshadowed already, the permission rules and the rules then work as a sanction now that there's been a breach. I understand the point. What I would like you to think about, and maybe make submissions at some point, is the wider implications for this approach. Because the approach you're now putting isn't one which is specific to experts' reports. It applies to everything.
I accept. Look, I've thought about that.
Okay. Well, you can tell me the answer at some point. Do it now.
Well, I'll do it now because I was going to say you're absolutely right. The point I was going to go deal with the second stage, and I accept that none of the provisions of the rules I've identified sort of express or contain an express sanction. There's no unless orders. All of that. I submit that we're either in the second or third categories of FXF for the reasons that I've foreshadowed, and it's my contention that one of the reasons why the claimant needs an extension of time is because of the practice direction, paragraph 6.2, the assumption the court's required to make the claimant's got to persuade the court to depart from that assumption before we can ask the court to entertain the application. And I accept that you might balk at what I'm suggesting and think, well, hang on, if I'm suggesting this, then what implications does this have for any direction a party might see? Well, the answer to that is, well, there are two answers to that. The first is, well, you can say, well, the reason that it's a reasonable approach in this case, in the context of expert evidence, is because of 35.41. Because 35.41, the wording of it operates as a sanction. That would be one reason why you can limit this to expert evidence. And another reason is that expert evidence has far more potential to cause damage to, or the late introduction of it has got far more potential to cause damage to the efficient conduct of litigation than, for example, the amendment of a pleading. The amendment of a pleading may or may not, and frequently does not have much, if any, effect on the efficient conduct of litigation. It might be a technicality, it might be a new argument, but based upon the existing evidence.
Well, a late introduction of fundamental dishonesty.
Well, that wasn't a late introduction, by the way. And the reason it wasn't a late introduction, as you make the point, and my lord makes the point, is because we've been chasing those DWP records from the beginning of January 2021. There can be no misunderstanding as to why we were asking for the claimant's wife's DWP records, and that wasn't a request we made at the last minute. We made that request when disclosure was given, because we said, well, hang on a minute, where are the records that from the claimant's wife who was allegedly provided all this care? Bearing in mind her statement says that she had fibromyalgia, and it took until over halfway through 2021 before we got the records. They were only received shortly before that county schedule was drafted. So it wasn't late. It might look late, but it wasn't. It was something that was foreshadowed well in advance. So, back to where I was.
Sorry, Mr. McCoy.
Yes, of course.
If I may push you a little bit harder on this point.
Yes.
Why doesn't your analysis apply to pleading amendments?
Because
you always need the court's permission to make a pleading, to make an amendment. So there's the analogue of Rule 35.4.
yes.
And I'm at the moment, speaking for myself, concerned that the approach you're taking would mean that an application to amend pleadings after the CMC would be one that has to be dealt with under relief from sanctions.
I understand that, but the answer to that is that this court can make clear that there's a distinction between the two, that the pleadings and expert evidence don't fall to be dealt with in the same way. That's the answer. And the court can adopt my analysis and say, we're going to do this incrementally, and this is the analysis we're going to adopt in relation to expert evidence, but not pleadings. The court isn't duty bound to say, well, that because it accepts this analysis in relation to expert evidence, that it necessarily will apply to everything. And it won't cause a problem for other things. If you think about, for example, pre-trial checklists or trial bundles, well, the party doesn't need to apply for permission to rely on a late pre-trial checklist. It's just an administrative thing. Likewise, a trial bundle.
Well, that's why I picked pleadings.
Yeah, well, I thought that's why I was thinking about pleadings, and I accept that that is a potential concern.
What about disclosure? If you find a document later, let's say in good faith, you find a document after you've given disclosure, which you've done a reasonable search, and you haven't found it, you found another one. Don't you need permission to serve a supplemental list or whatever the right expression is?
Well, 31.13, I think, contains an express sanction law. Does it? No, it's 31.21. 31.21 says a party may not rely on any document which he fails to disclose or in respect of which he fails to permit inspection unless the court gives permission. So there's already an express sanction in the rules that if you don't provide your documents when you should.
Well, I know about that rule, but the point is, are you saying that the way that works is that all late disclosure is actually, although no one had noticed, a relief from sanction?
No, because of the provision in Practice Direction 6.29 and 6.4.
Which is what? The change
in circumstances. If you found something late, you're entitled to say, well, look, this is a change in circumstances.
Well, I thought your submission was that if it's the change of circumstances operates as a good answer on an application for relief it's still a relief from sanction, albeit one where you're happy to bring your trump card and say, I've got a change of circumstances.
Yeah.
But intellectually, as I understood it, your submission was these are all still relief from sanction.
It is. That's the position I adopted in the skeleton, because I felt it was better to have one test rather than to have arguments before Masters or the district judiciary about what test should be applied, because that's then going to give rise to potentially to a lot of appeals on whether the right test was applied. If we all agreed the test, but we said, well, the material change is a good reason on the stage 2, there might be fewer appeals. But so that was my first submission. But if the court isn't attracted by that, then obviously I say that you avoid the relief from sanctions analysis if there's a material change in circumstances. And that's obviously a decision, the court's got to make a decision there about what approach it wants to take. My view, well, my primary submission was that, be careful about saying it doesn't apply to it in other circumstances, because there might then be lots of arguments about what is the correct test, and then lots of appeals about it. Whereas if the same test applies, then it's always going to be within the discretion of the judge.
Thank you.
So I think I've dealt with in my submission, we're either within the second or third categories of FXF. In my submission, there is no legitimate or logical basis on the facts of this case to adopt a more lenient approach to the claimant's application than, for example, first, a case where a party has failed to make an application for expert evidence by a date ordered by the court, in other words, sort of MS a child situation, or second, where a party has failed to serve an expert's report by the date ordered by the court, in other words, the Boyle or Elliott situation. In both of those situations, the Denton test applies. I submit a party who, for no good reason, fails to make an application for expert evidence until a very late stage in the litigation should expect nothing less than the Denton approach, and I therefore invite my lady and my lords to reject the test in T and Imperial, and I submit the consequence of not rejecting it is that parties who do not even bother to think properly about what expert evidence they might need at an early stage in accordance with the rules are potentially in a better position than those who do. And I also submit that the test in T and Imperial, even if it's appropriate for pleadings, is not something which can or certainly should be co-opted to deal with expert evidence. The two things are completely different animals. And the introduction of expert evidence, after all directions have been completed, has got far greater potential in most cases to cause disruption to litigation because of all of the knock-on effects. And the respondent's skeleton argument suggests the application of the Denton test in the circumstances of this case may water down the relief from sanctions regime. In fact, I submit the regime is more likely to be undermined if the test is not adopted for the reasons I've already explained, and the application of the Denton test on the facts of this case will reinforce the need for parties to comply with their obligations under the rules and the practice direction. It's suggested in the respondent's skeleton that my approach might inhibit parties from seeking permission to rely on expert evidence where it's not available by the time of the CMC, and I submit the opposite is true. If the parties know Denton is going to apply, they're more likely to find out in good time whether the evidence will be needed and to obtain it, or at least to mention that they might need it so that provision can be made for it in their directions. And I submit that there's nothing to fear from the Denton test being applied across the board in relation to applications in circumstances such as these. If there is a material change, then, as I say, that would be a good reason at stage 2. So in conclusion, on ground 1, I submit the wrong test was applied. I submit it's obvious that if it had been applied, there would only have been one outcome, which is dismissal of the claimant's application. It was clearly a very serious and substantial breach. There's more than one breach. and the breaches were at the uppermost end of the scale of severity. There was no good explanation for the breaches. There's no real prospect in my submission that the judges below would have allowed the application had Denton applied, and the district judge himself gave permission to appeal on the basis he may have been wrong to apply the Denton test, and he would hardly have done that if he felt that the conclusion would have been the same regardless. And the court will have seen that in March of 2022, in other words, 5 months before he ruled on this application, the judge had dismissed an application to allow 2 witness statements served out of time on the basis they were too late and CPR 3.9 applied. And that's apparent from his judgment at paragraph 15 on page 26 of the supplementary bundle. I submit it's just inconceivable that having done that, if he then approached this application applying the same test, he would have come to a different conclusion and allowed the report, particularly as allowing the 2 statements wasn't going to affect the trial date. Applying this application most certainly did. That leads me then to ground 2, which I can deal with fairly quickly, if I may. I submit this was not a finely balanced case in the context of the new procedural landscape ushered in by 3.9, 1.1 and the amendments to it, and indeed the decisions of this court. Even if the letter of Denton wasn't in play, the ethos of Denton certainly should have been. The factors referred to in A and B of 3.9 should have been at the forefront of the judge's mind and the decision. And first, contrary to the decisions below, the claimant's application was a very late application within the meaning of T and Imperial, as opposed to merely one that was late. The case was fixed for trial initially in April 22. That was vacated because the claimant couldn't attend. It was relisted as a fixture in September, and that was also vacated because he couldn't attend. And it's correct that by the time he ruled on this application, that a new trial listing had not been set. But I submit that doesn't mean that fortuitously for the claimant it was a late as opposed to a very late application, or that should have played any part at all. In reality, that was just coincidence. And the granting of the application meant inevitably there was going to be a much longer delay in the case coming on for trial. And if there's any concern about whether that's correct, one only has to look at the order the judge made on page 121 of the core bundle to see all the additional steps that had to be taken before the case could then be listed. Granting the application meant postponing the trial date for a minimum of 6 months. And I submit the difference between an application which causes a trial date to be vacated and an application which causes a pending trial listing to be substantially postponed is not substantial. If I could then ask the court please to turn to page 304 of the authorities bundle. We can see here practice direction 29, paragraph 7.41.
Sorry, what page are we on?
That's it, page 304.
304.
304.
Thank you very much.
Paragraph 7.4.
7.41. The court will not allow a failure to comply with directions to lead to the postponement of the trial unless the circumstances are exceptional. In my submission, the claimant's application engaged this paragraph. And the reasons it did so is because the words a failure to comply with directions don't simply refer to directions issued by the court, they refer to the directions also in practice direction 29 itself. Those include, for example, 6.21. It is essential a party who wishes to vary a direction applies or takes steps to do so as soon as possible. As I have highlighted already, the claimant was in breach of a number of provisions in the rules, the practice direction, as well as the orders of the court. So clearly, in my submission, he had failed to comply with directions within the meaning of 7.41. That failure meant, in my submission, there was going to be a substantial postponement of the trial date. And the words postponement of the trial date are wider, or postponement of the trial, are wider than merely vacation of the trial date. They're not limited to cases where the trial date or a trial date is vacated. The words are deliberately wide. Postponement of the trial also means where a trial perhaps is given a window, or indeed is not given a window, but is about to be given a window. And that has to be substantially postponed because of a failure to comply with directions. So I submit that the judge should have applied this paragraph, the judges below should have applied this paragraph to the claimant's application, as I invited them to do. That meant that the application should not have been allowed, even if one applies 1.1 and T an imperial, unless there were exceptional circumstances, and there was nothing remotely exceptional in this case to justify the granting of it.
So what application do you say they should have made? I mean, there was no listed trial. So you're going to get a puzzled look on you from the district judge when you say you're applying to postpone trial that hasn't been listed.
Well,
what does it even mean?
Well, but no, I don't accept one would get a puzzled look. If a postpone a trial means the hearing, it means that it's not just simply the trial date.
I understand the submission you made. You say that the words postponement of the trial, you say, can be read as meaning not only vacating a current listing, but making things later. I understand the point.
Yeah.
But you then said another thing. You said that your opponents should have applied to the court for an order. And I'm trying to understand what order it is you're saying. Part of your submissions, as you were getting, if I may say so, carried along with them a little bit. Was that they should have applied for something. You were saying they should have applied for.
Oh yeah, but no. What I meant was.
What I'm putting to you, I don't quite understand.
No.
I understand the point you say wider. Again, maybe right, maybe wrong. I understand it, but I'm struggling to see what order you could have asked the court to make.
No, I agree. What I meant when I said this, I may have misspoken. What I was referring to was the failure to apply at an earlier stage in accordance with 6.21.
Okay, I understand that.
That's the point I was making. Forgive me. I may have misspoken. I'm just anxious that Mr. Chapman needs a fair go, and I've had almost 2 hours already, so I'm deliberately hurrying up. I apologise if that was confused, but that was the reason for it. I say that was engaged and that should have been taken into account. The lateness of the application meant that the efficient conduct of the case was grossly disrupted, and the PTSH was effectively rendered a waste of time because it was conducted on the basis of incomplete evidence if this decision stands. The order the district judge made at page 121 of the core bundle says at paragraph 8, well, there has to be yet another CCMC. And the court should be aware and will note from the chronology and the index that the case had already been the subject of multiple interlocutory hearings. This wasn't the first breach or the first late act in an otherwise well-conducted case. It was the last of many failures to get the case in good order. And the court will have seen from my skeleton that the accident had happened in 2016, about 6 years before this decision was made. It was not 2019, as Judge Glen records in his judgment in paragraph 2 on page 70. Liability is in dispute, and the resolution of the facts on liability are highly material to breach of duty and causation, as one can see from the pleadings and the joint statement of the orthopaedic experts. And not only had the case been, was it an old case, it had been issued late, issued at the last minute, last second of the limitation period practically, and it had been served at the end of the 4-month window. One could see that from the particulars of claim in the schedule. And the reasons for allowing it in my submission were extremely weak. if one looks at what the district judge said at page 119 of the core bundle, the judge said in paragraph 17 on page 119 of the core bundle, in my judgment, the need for expert evidence in pain management is reasonably required to equip the circuit judge to dispose of this case. It would be wholly wrong to enable this claimant simply to go to trial on the strength of what Mr. Quayle is saying without any further material before the court. So that was the original reasoning. And then if one looks at what Judge Glen said about that, you'll find that on page 79 of the core bundle. It's paragraph 21 of the decision. The judge said this, the reports of Mr. Quayle with their recommendation for such evidence provide a reasonable springboard for the application. While the recommendation is clearly directed at treatment, it's not possible to say from a fair reading his report that it is exclusively so directed. It seems to me it could fairly be said to also encompass the respondent's present position and the causes of it, or for it. It was open, it seems to me, to the respondent to explore the cause of the ongoing chronic pain and whether it would necessarily have been a feature of his inevitable degeneration.
How does it come about, do you know, that in paragraph 12 of the district judge's judgment, he says that the diary manager tells him with some confidence that there can be a trial before December, and then he makes an order which puts it at least beyond March? Seems a bit
well
strange.
I don't know, my lord. The vagaries of listing at any court are beyond my experience. But if one, the only reason
he talks about the window of opportunity for the claimant to see the pain management expert promptly, which makes you think, jolly good, this is all going to happen quite quickly, and then for some reason it doesn't.
Yeah. Well, and it never was going to, though, because it wouldn't be fair to give a tight time to introduce a new expert and then to say, right, everyone's going to have to meet a very tight timetable now. As you can imagine, that's not something that we would be happy with. And the further directions were each side get a report, then a joint statement, we'll have an updated schedule and a counter schedule and another CMC, and there'd be cost budgeting to revisit again, and you'd be doing that. Having to revisit the previous order made 2 years ago, which is always extremely difficult because cost budgeting is supposed to be done once, really. It's not satisfactory to have to do it twice because it's a holistic exercise, and you look at the total figure in the round, taking into account everything that has to be done. I mean, it potentially would need two more experts at trial, a longer trial listing. I mean, the disruption is huge if expert evidence or additional expert evidence is introduced in this case. It's not just a fairly minor blip, as the judge seems to have assumed. And the only justification that he and Judge Glen came up with for saying, well, it's worth doing, is because they thought that the report was necessary. And Judge Glen, I've just taken my lady and my lords to paragraph 21, he says, it's also necessary to explore the respondent's present position. Well, that in my submission was just plain wrong for this reason. If one looks at the particulars of claim dated August of 2020 at page 134, paragraph 6 set out the particulars of injury. The pleaded case was it was a 4 to 5 year acceleration requiring 3 surgeries. And if then one looks at the schedule of loss, and I mean the updated schedule of loss, which the claimant was required to serve by August of 2021, and that's a paragraph, it's page 38 of the supplementary bundle. you can, my lady and my lords will see at the top of 38, the claimant's claim for loss of earnings is limited to 29th March 2021. Likewise, if one looks at the claim for gratuitous care, the claim is limited to March of 2021. That was because it was the midpoint of the 4 to 5 year period of acceleration. So, as at the date of the claimant's application in August of 2022, it didn't matter what the cause of his symptoms was. That wasn't an issue on the pleadings. The claimant was only claiming compensation for symptoms and the consequences of those symptoms up until March of 2021. Judge Glen's comment that it's reasonable to explore the cause of his present symptoms is not correct, because it wasn't contended that his present symptoms had anything to do with the accident. And that remained the position as at the date of the schedule. It's also important to note that Mr. Quayle had not asked, would not suggested, that a pain management report was required to deal with the issue of causation. It's important to look at page 82 of the supplementary bundle to see what he was asked before he prepared his third report. The instructions are at paragraphs 1.2 to 1.5. Now, he answered those questions at paragraphs 11.4, 11.5 and 11.6 on page 19. Nowhere in answering the question does he say a pain management report is required to deal with the issue of causation. He answers the questions and he gives his opinion. He doesn't say it is contingent on what anything else says, or that the question falls outside his expertise. His comment on the need for evidence from a pain management expert is to be found at the bottom of page 89 in paragraph 11.3. where he simply says, I would agree with the management suggested by the pain clinic, including the use of a spinal cord stimulator. This is not my area of expertise, and I would recommend the claimant be seen by an expert in chronic pain management to advise the court upon the claimant's problems and the treatment options available to him. My submission, if one reads the whole report, he is not saying that it is necessary to seek a report from a pain management expert to work out whether he would have had the same problems in any event. He's obviously concerned with the fact this man is in pain, or so he accepts, and that something needs to be done about it. And that wasn't an issue that the trial judge was going to have to grapple with for the reasons I have explained. In conclusion, therefore, when one looks at the weight of the factors that were against this application, everything that was against it, and what was in its favour, the so-called need for a new expert, there was a huge weight on one side of the scale. On the other side, there was hardly anything at all. And in my submission, it is remarkable that the district judge and the circuit judge both felt otherwise. I submit that that was a serious error of misjudgment, and one with which this court can and should interfere. I understand and I respect that the law is that the court will rarely interfere with case management decisions, but it's important that when they get it badly wrong, it does interfere, and it does make the point that this is not the approach to be adopted if the trajectory of the Denton ethos is to be maintained and applied. It would be a mistake to think that this is just one case, and if there's no harm in letting this go and treating this as simply a decision which perhaps other judges wouldn't have made, but not one that can be interfered with. It should be interfered with where it's so badly run. Those are my submissions, unless I can assist you.
Thank you very much indeed.
Thank you.
Mr. Chapman?
Ladies and Lords, I hope to be fairly brief. I doubt that I'll have finished by 1 o'clock. I'll try and go as rapidly as I can. I'll start with some very brief observations about ground 2, which is not wrong test, it's plainly wrong, on which you've most recently heard from a learned friend. And I don't propose to say very much more about that than is dealt with already in the skeleton argument of paragraph 22 through to 25. We say that on any analysis, the judgments of first instance and first tier appeal by District Judge Stewart and His Honour Judge Glen, respectively, are good examples, which we commend, of the sort of fair and robust case management that Lord Justice Davis had in mind in the Chartwell case that we drew our attention to yesterday. I'm sure Milady actually indicated earlier that you've done some quite wide reading in the core bundle, and therefore I don't propose to take you through it in detail. But the court will recall that actually the application that was made at first instance was successful in part with an appropriately nuanced cost order to reflect the fact that there had been some further case management as part of that application and its disposal to move the matter on, and that the claimant had been successful in part and unsuccessful in part, because there was an accompanying application, you may recall, not just for a pain management expert, but for a psychologist.
That was rejected.
And that part of the application was rejected. So you see a sort of nuanced approach that was taken at first instance, which, as I say, I commend as an example of robust case management. In respect of the report, the third report of Mr. Quayle, which clearly had a significant impact on the thinking of the district judge at the first instance. In paragraph 11.7, which is I've got it at page 90, I think I may be slightly awry in terms of the punched page numbers, but it's paragraph 11.7 in the supplementary bundle of that report. Mr. Quayle, in fact, was not limiting his view about the utility of a pain management expert to one issue or another, whether it be treatment recommendations, as he sketched out in earlier reports, or something going wider than that. It looks as though, so far as causation is concerned, he had dealt with that from an orthopaedic perspective. That was a matter that was subsequently discussed in a joint statement with Mr. Oxborough, the defendant's expert. His concern was in relation to pain management and this pain condition more generally. Causation, condition, prognosis, sort of things that you would expect an expert in a particular field to deal with. And the reason he had that concern, an obvious one which he makes clear, which is that was not his specialism. It was something that the court would, in his view, his recommendation, would be assisted by in a report from an expert in that field. It wasn't limited the way he dealt with it, and that was the way, in my submission, quite properly, that the district judge at first instance approached that. Just drawing those threads together in relation to the case management decision, we do say, looking at the exercise of the discretion in the way that it was exercised at first instance and then revisited first tier appeal, it can't possibly be said that in treating that application as being finely balanced, as the district judge expressly said in the course of his judgment, that in any way he exceeded, quote, the generous ambit within which reasonable disagreement is possible. That is, it may be a finely balanced matter, and it's clearly one where the defendant feels aggrieved, but it's not something, in my submission, which this court should interfere with at this stage.
Can you shed any light, I know you weren't there, but can you shed any light on the reason why he says there can be a trial in December and then makes an order? I wondered whether what he was saying was that if this new expert doesn't come in, we could simply fix this for December.
Yeah.
Whereas if the expert does come in, we have to make completely different
That
directions.
may be the appropriate assumption, but I'm afraid
In which case, if that is the position, introducing this expert report put off the trial by a minimum of 3 or 4 months.
Well, I don't think it's being suggested by anyone that, and indeed it was appropriately conceded before the district judge, that this was, leaving aside for a moment whether it is in the technical sense a very late application or a late application, this was a late introduction. I entirely accept that. That was conceded. And it was clearly a matter that exercised the mind of the district judge at first instance. It was one of the matters, one of the factors that he weighed in the balance. Not giving it disproportionate weight, but one factor to take account of. My suspicion that was perfectly appropriate. Laws in relation, that's in a sense is all I propose to say about ground 2, which is, as it were, wrong, plainly wrong results. The essence of this, of course, is whether this case should be approached on a relief from sanctions dental regime basis. And that's the core of this, in a sense. Wrong test, in other words, ground 1 of the appeal. And about this, I propose to advance in this way some, I hope, fairly brief observations on the procedural chronology, insofar as I've not touched on them already. Some reference to the authorities, and in particular, the most recent authority of this court, which was drawn very helpfully to our attention yesterday. It's a very recent decision of this month, in fact, which is the Lufthansa and Panasonic case, among others. And then I'll make some submissions on the appeal, which again I hope I can deal with relatively briefly. Can I say this by way of a headline? These cases do have a hierarchy, and to that extent there's a degree of common ground in the approach that both myself and my learned friend have taken, which is that one starts at the top end of the hierarchy with express sanction cases. Clear signal in the rule, practice, direction or order of the court as to what the consequence will be if there is a breach. The learned friend concentrates on breach. My suspicion he pays slightly less attention to sanction, but it's actually sanction that's important if you look at the authorities. Indeed, if you read 3.91, that's why we're here, because there is a sanction for which relief is needed. So we can have express sanction cases, and I think we agree that this is not an express sanction case, whatever else it might be. There is then, there clearly are implied sanction cases. And this is where this court in particular, has, in a variety of incremental stages, first actually limited to a sort of appeal setting, failing to get your notice of appeal, permission to appeal application in on time, as say as in Clark Walker case, and failure to get in a respondent's notice on time and needing an extension of time for that, which is the Salford Estates and Altamont case. So in those specific settings, the implied sanction regime has been applied, and we'll look at I can explain, I hope, fairly briefly the reasons for that in a moment. And more recently, in the FXF case, the, again, incremental extension of the implied sanction regime to an application to set aside a judgment in default. That's FXF. Save for the first instance cases, and in particular the SJ Moore case, we haven't, in terms of implied sanction yet, gone further than that. And there's a good reason for that, in my submission, which is that at a very high level of generality, the civil procedure rules are clearly intended to be a self-contained, largely self-contained procedural code with a series of clear signals to parties as to what is required of them and what will happen if they don't comply in the event of breach. The problem with implied sanction as it edges forward is it becomes more and more difficult clearly to signal to parties what is expected. In the exchanges that took place between the bar and the bench in relation to Part 29 and how that ought to be approached, looking backwards to whether there'd been a breach with a sanction that no one might know about, you see a very clear example in my submission of a lack of clarity as to the signal as to what the sanction might be. And that is the problem in my submission with implied sanction generally. Outside, of course, implied sanction, my learned friend's position, as I understand it, is that this is an implied sanction case. should be approached on that basis. But outside that, you've got the large number of all sorts of case management decisions that arise after the first CMC, perhaps en route to a second CMC, which often happens in personal injury and other contexts, or en route even to a pre-trial review, or when the parties put their directions questionnaires in. All of it happening after the first CMC. Whether all of those applications and case management issues should be subjected to an implied sanction regime. The short answer, we say, is that they should not. That takes away, that detracts from the clear signalling that a respectable and clear self-contained procedural code. In terms of, therefore, the very brief observations I make as to the procedural chronology, I hope some of this may be obvious, and I'll take it at some speed. The directions order that was made by Deputy District Judge Murphy on the 19th of October of 2020 dealt, of course, as the court will have seen, with only one field of expert evidence, namely orthopaedics. It doesn't contain, in fact, any unless provisions in the way that those are usually understood. There's no specified date for the service of all or any expert evidence. This doesn't look like one of those KB Masters corridor orders where you have a subheading that has at the top expert evidence and then specific provisions thereafter, or even, as in the MS Croydon case, a sort of fallback provision that if a party wished to make an application for expert evidence in additional fields, it should be done by X date. It isn't that sort of order. Page S, I put it at S15 in the supplemental bundle. And it's page 16 that contains the material. It clearly proceeded on the assumption that that's all there would be. But it doesn't contain any unless provisions or anything else.
And you would say, presumably, that the oral expert evidence at trial, referred to in paragraph 11, can only refer to the reports of the evidence of Mr. Crane and Mr. Oxborough.
They were the only matters.
Because you would never have oral evidence from an expert who hadn't dealt with his views in writing.
Oral expert evidence, a good example of the sort of thing that crops up after the first CMC. I'm not aware of anyone ever suggesting, certainly no authority on the point, that those should be treated as relief from sanction applications. Parties don't know at the first CMC whether they're going to need oral expert evidence at trial or not. That oral expert evidence can be fundamental to the outcome of the case, and yet it's usually something that's dealt with down the track. It's one of those case management issues that can affect the trial, can affect the listing for trial and the time estimate, but isn't known at the time of the first CMC.
So I'm just understanding the point you're making. I mean, I understand that it's not known, but then this order doesn't assume it is known. The order sets a date for it, which is in the future.
Yeah.
So how does that help you?
Well, I'm simply providing this as an illustration of the sort of case management issue that can arise after the first CMC. And as Malone said a moment ago, which I endorse and adopt, at the time that this order was made, only one field of expert evidence was in play, and it was assumed by the case management judge that this was all there would be. The second point I made.
Do you agree that do you accept that a third Quayle report that refers to the pain management was in?
Oh yes,
that
was my second point. I'm going to make this by way of the same concession that was made, which I've already dealt with, I hope, before the district judge on the application, which is that it is conceded that this was available to the parties and the court and the claimant at the time that this order was made.
Does the circuit judge acknowledge that?
The circuit judge?
Yeah. So, the reason I ask is that as I read the circuit, decision,
Yeah.
the way it's written puts the CMC directions in paragraph 3 and Mr. Quayle's report in paragraph 4 as if it comes after the CMC directions.
Yes,
I'd be happy to be shown a bit, but I haven't.
Yeah. That's the order in which it appears in that judgment. I don't know whether.
I don't recall. What I'm asking you, I suppose, is I may have missed it, but I don't recall reading it. I may well have read it and forgotten that Judge Glen identifies the fact that that evidence that refers to the pain management was available to both sides at the CMC.
Yes, I'm afraid I would need to have a look at the judgment again. I can't remember off the top of my head at the moment whether perhaps I'll return to that having a look over the shorter German. The point I was making is that this was a late application and it was acknowledged as such in front of District Judge Stewart in first instance. You can see that at paragraph 6 of his judgment. And it was explained on the basis that there'd been a subsequent review by a different fee earner who reached a different view as to the reach and ambit of the expert evidence that was required in this case, unsurprisingly. The point I was going to make is that this expert evidence from Mr. Quayle in the third report was available, of course, to all parties, and indeed to the court. It wouldn't, although the claimant solicitors had not woken up to it at that point, it wouldn't have surely come as an enormous shock to the defendant that at some point someone would wake up to it. That is indeed what happened.
Sorry to be tedious. What puzzles me is that it's all very well saying, well, it was late because it all happened after the CMC, but this was evidence that was before the parties. I don't know if the judge saw it at the CMC. So one might well expect that if the point was going to be taken, it would have been taken at the CMC.
Yeah, well, I accept it should have been raised at the CMC. I accept that.
Yes. But it's not just. Yes.
I accept that, and indeed it was accepted before the district judge. It was one of the matters that he had in mind.
That it should have been raised at the CMC, not that it was very late. They're not the same thing.
I appreciate that. I appreciate that entirely. Whether it was very late, if one's dealing with that
Or
intent,
late.
yes, or late. Late is. It was certainly late, and it was certainly available at the time of the CMC.
Yeah.
In terms of the, I don't. In terms of trial listing, which is my third and final observation on the procedural chronology, however fortuitous, in fact, I think the first application for vacation of the trial date was dealt with by consent on the defendant's application. There were problems with availability, I think, but at the time of this application, there was in fact no trial window and no trial date. And my learned friend says, well, that for the purposes of practice direction 29, paragraph 7.41, that doesn't matter. There was still a postponement in the general sense, and I'm not aware of any authority for that proposition. But the reality is that for whatever reason, there was no trial date, no trial window in the office at the relevant time. The fact that the introduction of new evidence might affect subsequent directions is a matter that was within the balance, but it wasn't an application that necessitated the vacation of any trial that had already been fixed or identified by way of window. Lady Mills, I propose at this stage to move on to the authorities. I'm happy to carry on now.
Yes, please do.
I'm going to start with the case of. There are two cases that I've dealt with to an extent already, which is Sayers and Clark Walker, and Salford and also Mars. I don't propose to say anything more about Sayers and Clark Walker. That's the failure within time to seek permission to appeal. That was a somewhat antique authority now. It's 2002. It predates Denton. It predates some of the other authorities do the present iteration of CPR 3.9. This was I'm going to start, if I may, with Karbari and Ahmed. This is, you'll find in the authorities bundle at page 54. A 2013 decision. This was the defendant seeking permission for late witness statements and for amendment of the defence, the application being made on day one of the trial. This is the case, if you recall, where Mr. Justice Turner held that there was, quote, no legitimate conceptual distinction could be drawn between the consequences of a failure to serve expert evidence and witness statements, and where the then current test in the case law on relief from sanction being Mitchell rather than Denton was applied to the application. The observations that are made about expert evidence in this case and CPR Part 35, we say, are overturned because the case was actually not in fact concerned with expert evidence. It was a case about witness statements and amendment. Insofar as there is reference to CPR 35.13, which appears in paragraph 22 of the judgment and is discussed at paragraph 23. I understand there to be at least common ground between myself and learned friend in this regard, that if there had been in the CMC order in this case a named expert and a date for service of a report, then CPR 35.13 would be engaged, and we would be looking at an express sanction scenario rather than an implied sanction scenario. And therefore, this is Obiter dealing with a rather different scenario.
What was the order made in this case? Do we get that?
We don't always get that in the authorities, actually. It's not always entirely clear. Give me a moment, I'll see if I can find it.
I mean, is this a different kind of expert case, like this case? Or
Well, it's not an expert case at all. It's
it?
a case about witness statements and
I see.
the defence. So, I mean, there
Yes,
is
I see.
The references to expert, it's talking about Boyle when it says.
Yes, it is.
21.
Yeah, it does refer to Boyle. I think I looked in vain for the date in this case for the service of witness statements. There would have been, but I'm afraid I couldn't find it. The case that was drawn to our attention by the court yesterday, which is Chartwell and Fergie's 2014 decision, which is not in the bundle. This was another case failing to serve a witness statement of fact within time in breach of a court order. There was relief from sanction that was granted at first instance, and the defendant appealed, and this was a Mitchell relief from sanction case that predated Denton. The appeal was dismissed. The court appeal in that case, in Chartwell, did not interfere with the extension of time that was granted on application of Mitchell and grant of relief from sanction at first instance. There's commentary about the provision of the rule that does contain a sanction for failing to serve your witness statements of fact in time, which is CPR 32.10. So this is an express sanction case, and therefore, I would submit limited application to the present case. The position is different in this case. This is not CPR 32.10. We're not looking at witness statements. It's not CPR 35.13, express sanction, where there's an order for disclosure of an expert's report by a certain date. This is common ground, if anything, outside express sanction. There's quite a lot in the judgments of Lord Justice Davis in particular, to which I referred on ground 2 of this appeal. At the conclusion of the judgment, I'll give Lady Malords the paragraph references. It's at paragraph 62 and 63. where the court, at the end of having dismissed the appeal against the grant of relief at first instance, went on to look at 3.9 in a more general sense as part of an umbrella of case management discretion that might operate, and said this. It's also to be emphasised that the courts, in considering applications under CPR 3.9, do not have and should not have as their sole objective a display of judicial musculature. The objective under CPR 3.9 is to achieve a just result, and in regard not simply to the interests of the parties, but also to the wider interests of justice. As has been said by the Master of the Rolls in his 18th lecture, enforcing compliance is not an end in itself. In the well-known words of Lord Justice Bowen, the courts do not exist for the sake of discipline. Such sentiments have not been entirely ousted by CPR 3.9 as to be interpreted and applied in the light of Mitchell. So, I mean, that's in the very specific context of relief from sanction in CPR 3.9. But it might, those sorts of words might have also an equal application to ground 2 of this appeal and the exercise of the general discretion that was exercised at first instance in this case. Salford Estates number 2 and Altomart. Lady rules may be comforted in knowing that I'm not going to refer to every authority in the bundle, but I will pick my way through them. This was the case where, in an appeal setting, this time a respondent's notice, the implied sanction regime was extended to an application for an extension of time for filing a respondent's notice. This was treated, as I say, as implied sanction. It's in the authorities bundle at page 169. That's a 2015 Court of Appeal decision. And the principal judgment was provided by Lord Justice Moore-Bigg. And the paragraph that I particularly wish to refer to is, within the One Weekly Law Report. It's at page 174 in the authorities bundle. It's page 1830 H. And it provides, albeit fairly briefly, a rationale for extending the implied sanction regime to a respondent's notice and an application for an extension of time in that context. And what's said there is the purpose of the respondent's notice is to enable Altomart to rely at the hearing of the appeal on grounds for upholding the judgment that were not before the court below. If an extension of time is not granted, it will be unable to do so. To that extent, that area of dispute will not come before the court. In my view, for a respondent to be prevented from pursuing the merits of a case it wishes to pursue on the appeal is no more or no less, or less of an implied sanction than it is for an applicant to be prevented from pursuing its case on appeal. So that was the reason for extending matters in the Salford Estates case, and it was an extension of the approach that had been taken in the earlier Court of Appeal, Sayers and Clark Walker, where the implied sanction regime had been applied to an application for permission to appeal and an extension of time for that. So this was treated as sufficiently fundamental and as going to the merits of the conduct of the appeal to justify the finding of an implied sanction, even in the absence of anything expressed in a rule, a practice direction, or any order that would be made by the court.
Sorry, Mr. Chapman. You're saying that this is a conclusion, but it's the importance of something that is the reason why it's an implied sanction.
Well, it was treated in this case, explained by Lord Justice Moore-Bigg in this case, as fundamental to the merits of the appeal. In a subsequent case, that was picked up, the subsequent case being Mark and Universal Coatings, which is referred to in the Lufthansa case, but hasn't yet been discussed in today's argument.
I'm going word blind. I don't see fundamental anywhere in this bit that you showed us.
It's a paragraph H at the bottom of page 1830 in the One Weekly.
In paragraph 16 of the judgment.
It is indeed.
I'm sorry, I'm sure it's there. I just don't see it. All right.
The word fundamental doesn't appear. That's my gloss on it. Sorry, that's my gloss. Yeah. The merits.
Well, that's my question.
I'm so sorry.
the reason I'm asking the question is because, I'll tell you frankly, as I read this, it's not saying what you just said. It doesn't say that it's because something's fundamental that is the reason. It says that if you look at the structure of how the provisions work, it operates as a sanction.
Yes.
You're saying that that's not what's being said. You're saying it's because of the importance of something that is the reason it's to be treated as a sanction.
Yes, and in that regard, I'm adopting the characterisation of this part of the judgment that was adopted by Mr. Justice Martin Spencer in the Mark and Universal Coatings case. So it's his explanation that I'm adopting for these purposes. I should say, actually, while I'm referring to that subsequent judgment of Mr. Justice Martin Spencer, that he could see this argument of it going to the merits and being so important that it should be treated as an implied sanction case as being applicable where the court was considering a time for seeking permission to appeal. He thought that a respondent's notice was rather closer to the lines, I think he put it in that judgment, than applying for permission to appeal.
Are you taking us to Mark?
I was going to, but I'm taking them in chronological order because they often refer back to each other. So,
Okay.
if I may, can I take the Elias and Stobart case?
Well, if you're not taking us to Mark right now, I think it's the appropriate moment to rise. I was just wondering whether I was interrupting your flow in relation to the merits point. But as you're taking it later in any event, I think we'll recommence at 2 at 2:05.